2. Order. Good morning. It's 29 minutes past 9. We are ready to start the day's proceedings. Please make sure that all your devices are quiet and silent. Thank you.
Good morning, Mr. Good morning, Mr. Bodlani.
Good morning, Chair.
Good morning, Advocate Johnson.
Good morning, Chair.
Let's start here. You remember yesterday we gave you some homework that stemmed from a question put to you by Commissioner Baloyi. And that question concerned the 4 counts that General Masemula is charged with, all of which are based on the Public Finance Management Act, or the PFMA as it is usually called. Commissioner Baloyi's point was, Commissioner Baloyi suggested to you, and she wanted a response, that those charges cannot stand alone. They must be related to some other offenses that do fall under the mandate of IDEC. You remember the question. I added to that question the fact that the section actually makes reference to additional. And I said to you that surely this must mean that the offenses under paragraph C of section 7(1), capital letter A, those offenses under the specified statutes there must therefore be, because of the use of additional, be additional to something that's already referred to. And if it's only offenses under the statutes, then IDEC does not have a mandate. I even said to you, you must give meaning to the word additional. In fact, I should actually have gone further than just additional. I should have said that this is additional related, so underline related as well, statutory offenses. So you would have to give meaning to additional related statutory offenses. And if what General Masemula is charged with are only the statutory offenses, in fact, in this case, statutory offenses relating to only the one statute, the PFMA, on what basis does IDEC have a mandate to charge General Masemula under the PFMA, standing all by itself? Unless you have a different, or you give the words additional related statutory offenses a different meaning to the one I'm suggesting to you. Can you please respond?
Good morning, Chair and Commissioners.
Yes, good morning. Good morning, Advocate.
I've done the homework. I don't know if I'm going to pass, so we're going to give it the best shot that I could. I did go back, and it is correct, Commissioner Baloyi, that he faces charges relating to the PFMA. And so we've got to go back into Section 7, especially 7(1)A, and say, in the absence of. Now, we have several accused that are charged. And you will find that not all of the accused are charged for all of the same offenses. You may find that some face 3 or 4 and some face just 1, etc. But they all arise out of the serious, complex corruption and commercial crime matter, which is the Medicare matter. It is in that vein that we go back Chair. And when we look at section 7(1)(a), the sub-A, our case, the Medicare matter, relates to serious, high-profile, or complex corruption, commercial or financial crime cases. That is the umbrella of the cases. The involvement of Commissioner Masemola in relation to the serious, high-profile or complex corruption, commercial or financial crimes are as related to the PFMA. When these offenses were allegedly taking place, the serious, complex, commercial, General Matlow, from the risk audit of the police, brought it to the attention of the then commissioner to say that there is these offenses taking place. There's unlawfulness happening in this contract. And Commissioner, as the accounting officer, you need to stop the contract and therefore it would therefore stop the payment. It took him a long time to do so. And what then happened is, in not acting in terms of his duties as the accounting officer, to act promptly, to act diligently, monies were in fact then paid out because of these unlawful corrupt activities in the approximate value of 50 million rands. And then the contract was stopped. He said it is all flowing out of the main transaction. It was brought to his attention, and the bringing it to his attention is because he is the accounting officer. And had he acted, then the perpetuation of this unlawful corruption, commercial and financial crimes would not have taken place. It is so, Chair, we never said that he was party to the corruption, but he is being charged then for the PFMA arising out of those matters that he had become aware of, and that we say he then did not stop. And that is as...
That's a valiant attempt, but I do not think it takes you to a pass mark. Let me make a very cruel example and say, let us say all of the people that General Masemola is charged with were dead, all of them. And therefore, there was no question of them being charged with all the offenses, with any of the offenses you are seeking to rely on, and to suggest that General Masemola's charges are additional to. So General Masemola then has to be charged under the PFMA all by himself. So what would the PFMA charges be additional to? What would the PFMA charges be additional to? Nothing. You get my point.
Yes.
So it's on that basis that I say your attempt to just force the PFMA charges being additional simply does not work. Do you agree? It doesn't. It doesn't. Because all that General Masemola is charged with are the PFMA offenses. So when you look at him, those offenses, insofar as General Masemola is concerned, are not additional to anything, are not related to anything. It's just those PFMA offenses only. And you cannot force the additional by merely relating to charges faced by other people, charges that have nothing to do with him whatsoever. And the cruel example I give actually makes the point abundantly clear. Do you agree?
I agree, it makes the point clear.
Yes.
If you'd allow me to, and then I stop.
Yes, yes.
In the manner in which it transpires, the PFMA is in relation to, and that is as far as I take it, it is in relation to the serious, complex corruption, commercial and financial crimes. If those had not taken place, there is no need for the charge to be preferred, PFMA or otherwise, against Commissioner Masemola. But that is as far as I can take that argument. And I just wanted the opportunity to explain where I took that in relation.
But for as
I
long
hear
as,
you.
oh, sorry, please finish.
No, I said
Yes.
that is as far as I'm able to take it because it is in relation to.
Yes.
Had those not
You see,
happened, there wouldn't have been these charges.
Yeah, you see, for as long as you agree with me and you are not able to argue against my cruel example, that point simply does not work. It doesn't. Because if he was all by himself, you couldn't, it would be nonsensical to talk about additional, because it would be additional to what? Additional to what? Because that additional is a conscious choice of word by the legislature or the legislator. It's a conscious choice of word. Otherwise, they would just have said relating to these statutory, or rather, offenses arising from these statutes, and then the statutes would be itemized. The use of additional is because there must first be other offenses. Otherwise, additional simply does not make sense. You must accept that.
I leave it there, Chair.
Do you agree that otherwise
I have to
you
agree
would,
with your reasoning.
Sorry.
I have to agree with your reasoning.
Thank you.
I made the point I thought I need to make.
Yes,
It
yes.
is based on my understanding.
Yes, no,
And
yes.
I have.
Yeah,
the
I
point.
suggest to you, or as other people would say, I put it to you that your reasoning in this regard,
Will not hold water.
it simply does not. Thank you.
Advocacy Law, there's a further issue on this. If you go to file 9 on page 3520, this is General Matlow's own affidavit.
Sorry, Advocate Johnson, you should not leave your seat when your testimony is concluded, being under the belief that the commissioners are suggesting that General Masemola has no case to answer insofar as the PFMA is concerned. We are not suggesting that at all. What we are focusing on is IDEC's mandate. IDEC, insofar as the PFMA is concerned, on our reading, IDEC's mandate is only if there are other charges and then the PFMA charges are additional to that. That's all that we are saying at this stage. It's about IDEC's mandate.
I hear
You
Chair.
see what I mean?
I understand.
So whether or not PMA offenses have in fact been committed is something else altogether, but it's not something that must be pursued by IDEC. That's all we are suggesting to you.
Thank you, Chair.
Thank you.
Yes, thank you, Chair. Good morning, Advocate Johnson.
Morning, Commissioner.
I'm going to deal with process leading to the charges by IDEC. So the Section 27 affidavit or
Sorry,
additional...
Chair, I think sorry, Commissioner Khumalo, I don't know if the Chair found his file. It was you got file 9. Sorry.
Yesterday already I did. Thank you very much, Advocate Johnson.
In your response to Chair, you referred to General Matlow's affidavit. So if you look at General Matlow's affidavit starting on 3519, what she says in 3520 in relation to General Masemola is that, so first of all, she's the head of risk and integrity, so head of risk and compliance at SAPS. And she would have investigated these issues, as I'm sure her job description requires her to. And then she says in paragraph 8 on 3520, She then advised General Masemola to consider terminating the contract with Medicare to save subs from irreparable harm and to diminish the financial prejudice suffered by subs. Then she says General Masemola terminated. So General Masemola accepted the advice. Do you see that?
Yes.
Now, if you read section 86 of PFMA with section 38, what it requires is willful and grossly negligent conduct on the part of General Masemola. As I understand those two sections, they would kick in if, notwithstanding the advice by the head of risk and compliance, he does absolutely nothing. Because then that would be willful and grossly negligent. But if your head of risk says, I've investigated this, here is an audit report that shows that at the time when you did not know, some members of SAPS in supply chain were colluding with Mr. Matlala's company. And as a result, this contract was concluded. They were also colluding in relation to the issue of, I think it's in charge 3, of the orders, of the purchase orders, which is not something that as a commissioner you would generally know because it happens at supply chain level. If now head of risk investigates, gives you an audit report and says the purchase order process and even the granting of the contract from the beginning were tainted by criminality. You as accounting officer, you come in at that level and you say, now that I have all this information, what do I do with it? And if upon receiving that advice, you terminate the contract, where is the willful, intentional conduct and the grossly negligent? Because the way these charges are formulated, IDEC is basically saying from the date the tender was awarded, because they say from May 2024 until May 2025. So they say from the date the tender was awarded, already there was willfulness and grossly negligent conduct on the part of General Masemola. But that cannot be if you look at the issue of the purchase orders, for example, in count 2. Those only started coming in after the tender was awarded. And payments only happened after services were rendered. So it cannot be that from the 8th of May already, because there was no tender on the 8th of May. The service provider was appointed in June, and after they were appointed, we've had evidence that there were then meetings about how the contract is going to be implemented. And the contract was then implemented much later, from September onwards, if I remember Brigadier Macheng's evidence correctly. So it's not clear to me how in May, June, July, August, PFMA breaches could have occurred on the part of General Masemola. So do you see where I'm going? That you can only sustain the PFMA charges, the ones that are formulated at least. There may well be others that he's guilty of and we are not aware of. But the ones that you have in count 1 to count 4, you can only sustain them if, after he has received advice from the head of risk, he ignores that advice and allows subs to continue with this contract. I know I've said a lot, so maybe respond only to the last part. Assume that everything I said before the last part was just background.
So how I understand it is that from the time that he was informed by the risk officer,
Yes.
General Matlo, he took quite a bit of time before he acted on the information and the advice given. And it is precisely because he took a long time, it is in that period that monies became released. That is how I understand
But
it.
do you accept that, like any of us, when you get opinion, you first have to consider it, you first have to apply your mind to it before you act? Because if you act in haste, You could be sued for breach of contract. You could be sued for failure to apply your mind. I mean, some of the issues we've criticized you for was blindly accepting briefings without looking at underlying documents to satisfy yourself that, the Section 27 read with the Section 28 applications are actually consistent and they are relevant to the complaint of Mr. Adams. So one does not, in the normal course, you get advice today, you act immediately. In the normal course, you would apply your mind to that advice and you would ask questions if there's a need to ask questions. Because I don't see anywhere in General Matlow's affidavit where she says it took the National Commissioner 6 months after he was given the advice to act on it. Because that paragraph 9 says, I gave the National Commissioner advice and then he terminated the contract. So there's no suggestion if General Matlow is the complainant, there's no suggestion by General Matlow that General Masemola did nothing with my advice or he took inordinately long before acting on that advice. And as a result of his failure to act on the advice, there was the loss. How I read this affidavit, it says the 50 million is what was paid throughout, not after the advice was given. But the charge sheet creates the impression that the loss happened after the advice was given.
If I could just indicate, Commissioner, that I asked if there was only the 27 at the time when they had this matter. I'm given to understand that General Matlow submitted a preliminary report together with the Section 27 affidavit. I'm not sure if it is before the Commission, but that must be something that that would then have to be asked, as it might just give a different context, but I'm not seeking to take the point further in terms of the conversation, Commissioner Khumalo, between you and I.
But looking at only paragraph 8, do you accept that the General says, I gave advice to the National Commissioner acted on the advice? The affidavit does not say the National Commissioner failed to act or did nothing with the advice given to him.
I understand that.
Yeah.
Still on this issue, my concern in the debate about whether or not this falls within the IDEC mandate is that on the charge sheet itself, there is no allegation of corruption. You don't make that allegation in the charge sheet. The charge sheet and the charges are purely statutory contravention, PFMA, and working off the charge sheet as it is now, the impression that it creates, or that in my mind has formulated, is that there was no good faith intention to prefer a charge because it is justified, it is supported by the facts. This was just a scheme to get him arrested or present to court, to have him appear in court, and the purpose is achieved just by that fact alone. So you don't even get to the validity of the charges. That's why we don't discuss with you whether there's merit in the charges themselves. That's for the court to determine eventually if it does. But that which is obviously, at least in my view, which is obvious from the charge sheet and must have been obvious to the lawyers in your office and to the prosecutor who approves those charges, it must have been obvious just on the charges that we are not making an allegation of corruption against him. how do we justify him being here? That must have been obvious. And accepting, because it's difficult not to accept that it was that obvious to the lawyers who dealt with this. Accepting that it would have been obvious to them that this charge sheet is wholly inadequate for purposes of our mandate. There has to be another reason why, anyway, you approved the charge. If you did do a prosecution memo, you were prepared to do the prosecution memo and say to the prosecutor, I think you said it's a DPP, and for the DPP to approve this charge as it stands without saying to you, hang on, go back, include corruption in there so that it falls within our mandate. To me, it gives the impression that the whole purpose of this charge sheet was to just have him appear in court. Just have him, let's create a paper that presents him to court and he becomes an accused with a consequence that we now publicly know happened, which is he was removed from his position, whether it's a leave or suspension, whatever, but he's not in office. And I say that, and forgive me if I'm repeating myself, I say that because it's inconceivable to me that a whole lot of lawyers who looked at this charge sheet, none of them said, hang on, we can't do this. This is not good enough for purposes of our mandate. If we want to charge him as involved in corruption, even your interpretation that you give to the chair this morning, if that interpretation had been discussed, it would find reflection in the charge sheet. However, inelegantly expressed, if the idea was that, well, you know, he's implicated in the corruption, even if it's just these sections, but that connection, it would have found expression here with a lawyer's eye. And that it doesn't find expression suggests to me is because you couldn't do it. None of you could get to the point where an allegation of corruption is made or him is being linked to the other accused conduct. And for that, you couldn't go that far, but it didn't matter because the real intention was never to get a successful prosecution of corruption or a successful prosecution that comes under PRECA. That was never the real intention. In my view, the intention was, as I say, get him arrested with the spectacle that comes with it, get him charged with a consequence that naturally will follow, which is the minister, and hopefully even he, National Commissioner, would say it's untenable for me to remain in this position while I'm undergoing a criminal trial, and that was its only purpose. That's what it looks like to me. You may comment if you want.
And I do understand your reasoning, Commissioner Baloy, but at no stage was there an intention to make a spectacle of anything. The prosecutors looked at the case in its totality, and as I explained this morning, it relates to. I accept, the only part that I do accept is they didn't draw the link between the two. That in itself does not make the conduct malicious, and there was no intent to put him on show. It was to charge him as they did. That link is not there. That cannot be taken away. But it should therefore not be seen as it was used as an instrument. They still firmly believe in those PFMA charges as they put them. And in my discussions yesterday, I did highlight that the Commission does find we have, where is the link between the two? Hence my explanation this morning. I took your point, but I have to clarify, there was never an ill intent. It might have been clumsily put in the way it is.
Or incompetently
drafted. Put, but that does not make for ill intent at all. Thank you, Commissioner.
Thank you. Thanks.
Seeing that we are dealing with these PFMA charges. Perhaps let me take you to a different but related issue. Ms. Sillo, please.
Yes, Chair.
Let me do so, Advocate Johnson. I'm sure you know what N156, so Criminal Procedure Act.
It's coming up, thank you.
Treated in same offense may be tried together. So I would say, please underline even that heading itself. Of course, our law and interpretation says a heading may be a guide, but is by no means determinative. But I will say, let's underline it. Then the subsection 1 reads, any number of participants, and I emphasize what follows, in the same offense, so you underline same offense, may be tried together, and any number of accessories after, again underline, the same fact may be tried together, or any number of participants, again underline, in the same offense, and any number of accessories after that fact may be tried together, and each such participant and each such accessory may be charged at such trial with the relevant substantive offense alleged against, I will say, them. Surely, in charging General Masemula together with people charged with fraud and corruption, you did not rely on section 155, subsection 1. I must be correct in that view.
That must be correct.
That's correct. Okay, let's go to, I don't think subsection 2 is relevant, so let's skip to section 156, which is headed, persons committing separate offenses at same time and place may be tried together. That too is quite crucial because I'm interested in if we look at what Commissioner Masemula is charged with, one immediately wonders if it can be said that he committed offenses at the same time and place with the people that he has been lumped with. But again, I will make the point I made earlier that a heading is merely of assistance and not necessarily determinative of the interpretation to be given to a statutory provision. Okay, let's go to the provision itself. Any number of persons charged in respect of separate offenses committed at the same place and at the same time. Underline that. Now it's in the substantive part of the provision, so no longer just the heading. And or at about the same time. So that too, at about the same time, may be charged and tried together in respect of such offenses. And then here's another crucial part. If the prosecutor informs the court that evidence admissible at the trial of one such person will, in his opinion, also be admissible as evidence at the trial of any other such person or such persons. Do you think this subsection applies? Or rather, this section, it has no subsection. Section 156, do you think it applies? In what way has General Masemula, based on the PFMA charges, committed those PFMA charges at the same place and at the same time as the commission of the fraud and corruption? Surely that cannot be suggested, I do not think. Same place, same time, about the same place, same time as the commission of the fraud and corruption? Not by any stretch of imagination, I do not think.
Correct, Chair.
So General Masemula was wrongly lumped with these other people. You must accept. You accept that?
I see that.
You certainly must. Now, even when you look at jurisprudential precedent, I will refer you to, I know you're a good prosecutor. I watched you arguing, which appeal was it? The Pistorius appeal. You are actually a good advocate, I think, on my assessment. I will refer you to jurisprudential precedent with regard to the court's exercise of discretion under section 1, under one of the sections I've just referred to. It should, I think, be relevant more to 156. Let me just see if the case was dealing with 156. Anyway, let me not waste time. Let me just read you what Trolip J.A. held. He says, in exercising its discretion, the trial court has to weigh up the likelihood of prejudice to the applicant accused. That is, the applicant accused would be the one saying, please, please, let my case be separated from the cases of these other accused. So the applicant accused, resulting from a joint trial against the likelihood of prejudice to the other accused or the state if their trials are separated, and decide whether or not, in the interest of justice, a separation of trials should be granted. Prejudice there means prejudice in the sense that no injustice should be caused to the party concerned, including the state. If we look at this, but what's crucial is that we've already accepted that in any event, General Masemula ought not to have been lumped together with these accused persons that are charged with fraud and corruption. Bear in mind that yesterday you accepted already that General Masemula is not complicit in fraud and corruption. Now you accepted now in my engagement with you now that he ought not to have been lumped together with these people. Now that he has been, surely, and based on this principle, you must also accept that he would suffer the sort of prejudice that Trolip J.A. says an accused person should not be subjected to. And I cannot see any countervailing arguments to the effect that the state will suffer any prejudice if he is not lumped with these other accused persons. Do you agree with me?
And if, I think when it was flighted, section 157.
Can you just respond to
Yes.
what I suggested
Yes.
to you now?
And I wanted to say that
yes.
because of, if you read 157,
Yes.
that becomes a bit more, is more appropriate then
Yes,
in
yes.
the circumstances and given the jurisprudence.
Yes, yes. But you basically agree with me, you've already agreed that he ought not to have been lumped together. Then I'm making another point, although related, which is that he will definitely be prejudiced in a trial that lumps him together with these other accused who are charged with fraud and corruption, both of which he is not charged with. Do you accept that?
I accept that.
Now, a question that goes to what I've always emphasized, I think I did so even on the first day, which is that we are not trying to suggest that the General Masemula has committed no offenses, no. But, and this is something that Commissioner Baloyi's question touched on, we want to know why this was done. Why was this done? You've agreed very easily. You know these principles. You apply these sections all the time. Why was this done? Why was Commissioner Masemula lumped with these people, charged with fraud and corruption when he is not? When he is charged with the statutory offenses provided for in the PFMA, why was he lumped with these people? At face value, it seems to me that this must have been done to embarrass him to taint him and to make the public or to cause the public to see him as also being complicit in fraud and corruption. People are not going to, ordinary members of the public are not going to analyze this. He stands there. People charged with corruption, fraud. He stands there with them. And most of the noise when the case is talked about is going to be about the fraud and corruption. People are not going to delineate and say, but not Masemula. Do you see what I mean? So this was done, I suggest to you, to embarrass him, to taint him, and to make him look as if he too has committed fraud and corruption. That was calculated, I suggest to you. What do you say?
Chair, I understand. I gave the contention that I did, that the prosecutors put him in one matter because there's the serious complex fraud corruption, and it would be one matter when they lead the evidence with the PFMA. I'm giving you the explanation that I have for the prosecution. I accept that this matter, he should be separated, but at no stage, Chair, was there an intention to embarrass. I can understand the optics thereof, but at no stage in the charging of Commissioner Masemola was there an intention that he be embarrassed.
Were you involved with the decision to join him as a co-accused in this, with the other accused? Were you involved with that decision?
Yes, the prosecutors take the decision. When we were briefed, we agreed that he's charged only for the PFMA.
No, my question is, someone made the decision that he will be accused number, whatever number, on that gallery, right?
The prosecutors.
My question is, before that decision or when that decision was made, were you party to that decision when it was made?
That he would be added at the end.
That he's added as a co-accused with the other, however number, whatever number they are.
Based on the contentions that I've given, which was given at the time, yes, ma'am.
You see, what's problematic with this is the fact that you have already agreed that in terms of the sections, he ought not to have been joined at all. He ought not to have been. Now, what makes this situation worse is the fact that he is being joined down the line. Not that it would have been correct if he had been joined at the same time the charges were brought. No, that would still have been legally wrong in terms of 155 and 156, and you've agreed to that. Now, but what makes it worse here, he is joined down the line. Surely your minds should have focused on, we already have charges against all of these people. We are charging them with fraud and corruption. Now we want to put in an additional person. Is it in accordance with the law to join him in terms of 155 and 156? Surely your mind should have been focused on that. It's not as if a mistake happened, we just lumped these people together instantaneously, it sort of just happened. But anyway, I say, things like these cannot just happen. So if it's wrong in law, it would have been wrong, even if it was lumped right at the beginning. But now, the point I'm making is, you lump those together, they are all charged with fraud and corruption. It makes sense to lump them together in terms of 155 and 156. Now with him down the line, how is it that your minds are not specifically or particularly focused on, but must we lump him together with them? Surely your minds should have been so focused. Otherwise, I do not understand why that was not the case.
I understand you, Chair.
Did you? I may be repeating Commissioner Baloyi's question, but I will repeat it for emphasis. Did you focus your own mind on this issue at all?
Yes, there was a discussion on whether he was going to be charged separately or whether he was going to be joined. I give the argument and can take it no further than what was given.
After that discussion, or during that discussion, did you specifically focus on which basis under 155 or 156 we can join him? Did you focus your minds on that?
Not me specifically.
When you said there was a discussion, did that discussion not involve you?
The discussion involved with 157. Should he be charged separately or should he be charged jointly? The prosecution
You
team...
can't, sorry. You can't separate 157. It must relate to 155 and 156 as well. You cannot separate 155 because you charge people in the same proceedings if they have committed the same offense.
That discussion happens and then we go to we then go to Commissioner Masemola
So you were part of that discussion, you say?
with the prosecutors. Yes,
You-
when they did the briefing.
Yes.
Yes, there was an engagement with the prosecutors.
Yes. And you concluded that there was a legal basis in terms of the Criminal Procedure Act to join him in these proceedings. And if you say so, and you must have reached that decision. So if you say you found a legal basis, what was that legal basis? And in terms of which section exactly?
So in terms of the legal basis that we found, Chair, it was the argument was used as the at the bottom of 156 of them being charged together because the evidence at the trial of the one would be used and may be admissible at the trial of the other person.
Is evidence about the commission of corruption, the commission of fraud, admissible as against General Masemola? If so, for what purpose?
Not admissible against him, but to lead that evidence to
No,
then
Joy, but-
show it.
Continue. Please continue.
Okay. It was in having this one trial, you lead the evidence of the fraud, the corruption, all of those irregularities. And it's all the same evidence that will then talk to the PFMA evidence, because you would have to lead, if you take him and put him separately, you would still have to lead that same evidence to get to him, to show what was the irregularities and or the unlawfulness that was happening, who all was involved, and what were his duties. So instead of duplicating that evidence, they put them all in one matter. We would lead that evidence. It will then in turn show that that serious complex corruption, etc., that happened, had it been stopped when it should have been stopped, would not have led to this. Not doing it together, Chair, as was argued, would mean we'd have to do two separate matters. That was the discussion at the time.
Was that correct, insofar as he is concerned? Remember, you just said, in response to my last question, you just said, evidence of the commission of corruption and the commission of fraud is not admissible as against General Masemola. And if you look at 156, that is what a prosecutor must tell the court as to why the prosecutor is joining the accused persons together. So if you accept, as you did in response to my last question, that evidence of fraud and corruption is not admissible as against General Masemola, you do not get off the starting blocks under 156. Do you agree?
I agree.
So he
I was giving you the discussions that we had.
which were wrong ultimately in terms of the decision that was reached. Do you accept?
I'll accept it.
Thank you.
Thank you, Chair, and Commissioners. Let's stay with, is it Major General Matlo's referral affidavit? And that's file 9, page 3519. And based on your, I think, our engagement yesterday with the commissioners on matters relating to General Masemola's arrest, this is our starting point, correct? General Matlo's affidavit is what eventually triggered the arrest, the eventual arrest and prosecution of General Masemola.
On a point of correction, I did indicate earlier that she submitted the Section 27
Yes.
together with a preliminary report.
Which preliminary report has not been provided to us. And I want to see how you reach that conclusion when on the wording, the very wording of the affidavit, there is no suggestion that anything is attached thereto.
I checked with the team, this 27. Did it have anything else? Because that is the question. In the absence of anything else, council, which was the conversations we were having yesterday,
Yes.
then a lot of things could not have happened. And I was informed that there was a preliminary report that was attached.
It doesn't particularly help the commission because only you and whoever it is you spoke to know of an existence of some preliminary report. The document that triggers this entire process does not even suggest it's submitting any further documentation, preliminary or otherwise. If you go to paragraph 5 of that affidavit, it speaks of a comprehensive internal report is currently being compiled. It doesn't say in the interim here is a preliminary report. So on a logical interpretation of paragraph 5 is that an internal audit process was underway. The fact that she describes it, the outcome thereof as a comprehensive report does not detract from the fact that it is underway. Do you agree with me?
I understand.
So I look at the rest of the affidavit, and there is nothing that suggests that even she, as component head risk and integrity management, had formed a view on the matter, however preliminary it is. Do you agree with me? At least based on the document itself. Do you agree with me?
I agree with you.
Yeah. Now, if we look at her paragraph 3, she says she wants you to investigate.
Sorry, paragraph 3.
Paragraph 3, yes, of General Matlo's affidavit. She wants you to investigate, you, IDEC, that's who I mean, the alleged unlawful awarding of a tender to Medicare 24, Tshwane district. You see that?
Yes.
Now, the charge sheet that came out of this entire investigation process invokes Section 38 of the PFMA, solely Section 38. And you know that if we take a step back, Section 217 of the Constitution prescribes that all organs of state should establish a system and make appointments regarding bid adjudication, bid evaluation, and that entire formal structure to deal with the issues of public procurement. So the awarding would have been done by, the recommendation would have been done by that procurement system. It then lands somewhere where the decision maker has to determine whether they accept the recommendation and they reject the recommendation. Is that your understanding of how public procurement works?
Yes.
And in deciding to reject, administrative law tells us that that decision maker must set out the reasons which must be reasonable and rational, because the responsibility and duty to manage matters of procurement lies elsewhere in the organization. Do you agree with that? Are you with me thus far?
I'm with you.
Now, with that understanding, if I go to the charge sheet and I look at charge 3, how do we rationally explain away charge 3, which is a charge of gross negligence for failure to comply, in that General Masemola, him, I take it as the accounting officer of SAPS, failed to ensure that Medicare 24 Tshwane district was properly screened and tax compliant? Whose duty is that?
That must be the bid evaluation.
So why, and now I'm just trying to get some, why is he being charged for failings by the bid evaluation committee, if we have since discovered that in the process of evaluation, it turned out that this particular entity was not tax compliant and neither was it properly screened? Unless we are suggesting the bid evaluation committee and the bid adjudication committee, after they have discharged their duties, the whole tender and process and documentation must go before General Masemola, where he must satisfy himself that this entity was tax compliant. Is that what we're suggesting? Amongst others.
Doesn't make sense.
I didn't think it would. Staying.
Please, please indicate to me when it would be appropriate to give Advocate Johnson the citation of the case I quoted from. I forgot to do that.
This would be good.
Should-
I'm happy to.
Thank you. I just gave you the name of the judge.
The matter from
Yes,
Trollop J.
the matter, yes. The matter is S versus Ntuli and
Ntuli?
others. And others. 1978, Volume 2, South African Law Reports, page 69, Appellate Division. Thank you.
Thank you, Chair.
Can I just add, without making a debate about it, a difficulty about this count that Ms. Silo has referred to, and which is part of what leads to my conclusion that I put to you earlier, is even this count, what that provision deals with is that the accounting officer must make sure that the institution complies with its tax obligations and everything that is listed there. So it's not even about that an accounting officer must make sure that people who are service providers have complied with their tax obligations. There's quite a few obligations that are listed there, but all of it is about you would have been entitled. Whoever charges him has jurisdiction, would be entitled to charge him for not ensuring that the SAPS complies with its tax obligations. You understand the difference? Yeah. So it's charges like that, a count like that, that reference to Section 38 as one of the charges against him that feeds the suspicion that I have about the motive of putting these charges, and me saying, but lawyers could never have missed that Section 38 1E has nothing to do with his involvement with the tax compliance of Mr. Matlala's company. It has to do with SAPS's own tax compliance. You understand what I'm saying?
Correct, because there's supposed to have been other functionaries
Yes.
who would have gone through that process of the bid and the evaluation relating to Mr.
I think
Matlala.
I'm making a different point, that 38 1E is not about service providers' tax compliance.
Yes.
It's about SAPS's own
Compliance.
with its tax obligations.
Yes.
And so the charge, and I mention it only to say it's part of what feeds suspicion about what was the purpose of these charges, which clearly seem to be poorly conceived against the National Commissioner, at least by IDEC. Thank you. Ms. Silo, thank you.
Thank you, Commissioner. And Advocate Johnson, that precisely makes the point, because Section 38(1)E, as Commissioner Baloyi correctly points out, is in relation to subsist tax compliance. Yet the reading of that charge suggests that Tshwane, is it Medi 24, ought to have complied with that particular section, and that General Masemola failed to ensure that Tshwane complies with that section. You see the challenge?
Yes.
And the interesting thing is the entire charge sheet is based on Section 38, and I'm just going to quickly project Section 38, because I think this is what leads to the challenges, for instance, in count 3. Section 38 of the PFMA prescribes that the accounting officer for a department, trading entity, or constitutional institution, sub A, must ensure that the department, trading entity, or constitutional institution has and maintains, and I will go to Roman 3, an appropriate procurement and provisioning system which is fair, equitable, transparent, competitive, and cost-effective. On a reading of that, you would agree with me that that is the responsibility that General Masemola bears. He must ensure SAPS maintains an appropriate procurement and provisioning system that is consistent and compliant with Section 217 of the Constitution. Now, it is that system that receives, interrogates, bids. My logic, which may very well be faulty, would be his failing to the extent that it falls within 38. The charge ought to have been, my view, that he failed to comply with 38(1)A Roman 3. He did not ensure SAPS has got such a system. Would you agree with that?
I agree with that.
Now, if we go back to charge 2, and charge 2 I will read with General Matou's referral affidavit at paragraph 3, just to remind you, at 3519, General Matou had indicated that she was initiating a criminal investigation into the unlawful awarding of a tender to Medicare. And if one has regard to 6, we learned that 7, we learned that Medicare 24 was awarded that tender, and resulting in a contract being concluded. And at 8, we learned that General Masemola terminated that contract. Firstly, if then we follow the logic of procurement, of a bid process, it culminates in a contract, and as General Matou points out, that contract brings into being contractual rights and contractual responsibilities and liabilities. So I suggest that once a contract has been concluded, which on the face of it brings about the rights and liabilities, that contract must be set aside, lawfully set aside. Do you agree with me?
Yes.
And in fact, it would appear that becoming persuaded, he actually chose to cancel the contract. And I don't know if you are aware that Mr. Matlala attempted to go to court, or there was discussion between him and other members of SAPS to challenge what he termed the unlawful termination of the contract. Now, I go back to the affidavit, armed with the knowledge that we have in the affidavit, knowing what he did, appreciating the legal parameters of what he could do and not do. How do we even get to investigation stage? At which point do you say, as the accounting officer yourself, if you're accounting officer of IDEC, the head of IDEC, at which point do you say this is a non-starter insofar as Masemola is concerned. Remember, I rejected the notion that there was a preliminary report, and I rejected on the basis that this very affidavit doesn't even suggest one was tendered. How? I still have a struggle with how this even saw the day of light insofar as Masemola is concerned. And I was hoping that perhaps you might shed light and draw attention to some document that perhaps we may have overlooked.
I can't take you any further other than if they had presented the preliminary report, it might have given us a different perspective. Not having it means I have nothing to give you.
Yes. Now, it's a pity the system is a bit slow. You recall yesterday I suggested to you that that internal audit report that General Matlou references at her paragraph 5, as I understand things, it's what gave General Masemola the basis to terminate. You don't have to agree with me. It's what I have learned in the course of investigations. So when it does come before us, its date would precede the date of termination by General Masemola. So he acted upon the advice of internal audit, seemingly. Would you have difficulty with that proposition?
I have to take your word for it because I have not seen it and I don't know it.
Yes.
And I don't believe you'll put a proposition that later on you can't back up. So
No.
I accept it, Council.
Thank you for the confidence.
The same point you made with paragraph D of section 38, with paragraph
Yes.
E, applies with regard to count 2 and paragraph D.
Indeed.
Because if you look at F says he must settle all contractual obligations and pay all monies owing. So for as long as the contract was alive, he had an obligation to pay Medicare 24. D deals with something completely different. So breach of D is not consistent with count 2. Because count 2 is about it's about maintenance and management of assets. So make sure that assets don't get lost. Make sure that if you have liabilities, they are managed. But the charge says he shouldn't have paid invoices. He shouldn't have accepted orders. Now, if he did as the charge suggests, he would have breached F of section 38(1).
Indeed, Commissioner, and to assist you, Advocate Johnson is projected the subsections D and F. We've spoken about E, D, F, and D is relevant to count 2. It is on the screen, and that is what Commissioner Khumalo is referring to.
So under F, Advocate Johnson, for as long as the contract was alive, SAPS had an obligation to
Pay the
accept
contract.
purchase orders and to pay invoices. But the charge suggests that General Masemola should have acted contrary to 38(1)F and not paid the invoices and not have accepted the purchase orders.
I see.
Do you see the problem there?
Thank you, Commissioner. And then staying with the issue of the internal audit report, which you accept, my proposal that it is on the basis of that internal audit finding that General Masemola terminated the contract. And the proposition to you was if he terminated on the 15th of May, that audit report was availed to him prior to the 15th of May. You do accept, you said you accept, at least for the moment, because you haven't seen it, I accept that. And I thank you for having the confidence in me to accept my say-so. The point I seek to make now, though, is the facts of that report and the findings only came to the attention of IDEC on the 26th of June, 2026. Now, as I was complaining that the system is rather slow this morning, that was by way of a further affidavit by General Matlou, dated the 26th of June, 2026, which currently, I guess, is in printing and copying. It's a big document in that I think it's a 284-page affidavit in which the introductory paragraphs are the same as any affidavit. From paragraphs 2 to the penultimate paragraph, it's the entire reproduction of the report itself, together with its findings and recommendations and everything. And then it's got whatever paragraph it will be as a concluding paragraph. And she signs it on the 26th of June, 2026. So officially, for purposes of investigation, that is the first time IDEC even becomes aware of the basis on which General Masomula eventually had to terminate on the 15th of May, 2025. You would accept that. Logic would tell me. Unless, once again, you or somebody within IDEC were able to explain that they obtained that audit report prior to the complainant, General Matlou, submitting it in a form of an affidavit on the 26th of June, 2026. Now, to the extent that your investigators told you there was a preliminary report, which of course I take issue with, did they indicate when they received that final audit report prior to the 26th of June, 26, if they ever did?
No, I just know that there was a preliminary report with the Section 27.
Then
I don't have the details, Chair, unfortunately.
We will await that affidavit and see. Now, this is, again, I'm still staying with General Matlou's affidavit, and it's because these are now significant and important institutions in the country. This is IDEC, SAPS. When this affidavit is received in the terms that it is, it does not at least implicate General Masemula on the face of it, does it? The affidavit at 3519.
Oh, you're talking about the Section 27, sorry.
Yes, the Section 27
Yes.
from
No.
General Matlou.
No,
It doesn't implicate General Masemula.
sorry.
The only reference I see to General Masemula is at paragraph 8,
Yes,
wherein she states that she advised him to terminate, to consider terminating, which he eventually did on the 15th of May.
correct. But she does go on to say, in her way, that having advised the National Commissioner to terminate the contract with Medicare to save the SAPS from irreparable harm and to diminish the financial prejudice being suffered by the SAPS, General Masemola ultimately terminated the contract with Medicare on or about the 15th of May. By that time, SAPS had suffered prejudice of approximately 50 million.
And that prejudice of 50 million being what SAPS was obligated to pay in terms of the contract. That's what you call prejudice.
At that time, when she told him about the termination, she indicated this contract is unlawful and should be stopped. So I don't know how the payments then become legitimated.
So
I understand that the system in terms of the system, there is a contract, till it is stopped, payments will continue. I understand this to read,
Advocate Johnson, apologies.
sorry,
You and I know she has no power to invalidate a contract which on the face of it is valid. So when she says stop that contract, in what capacity? She's not a court.
she's not a court, no.
Yes.
But she is the risk, she's the head of risk and integrity, and she is saying to him that this contract has been unlawfully awarded and we need to stop the contract. She says because of the time that has passed, the payments went out.
Sorry, this affidavit doesn't say when she told him to stop. So, on this affidavit, at least we who are reading it now, and maybe you had other information that is not in the affidavit. On this affidavit, we don't know whether she told him or in January, whether she told him on the 14th of May, and what the expenditure was by the time she told him when it dawned on her that this contract should be terminated. So it's not, what you're telling us now is not in the affidavit, so maybe tell us, where did you get it from that she told him to terminate, he did not, and in the intervening period after that, and the 15th of May, 50 million rand was spent, which would not have been spent had he acted when she told him. There's facts that are not contained in this affidavit, and they hold only if you got them in another way.
I understand. It's how I read the affidavit, that there is, in paragraph 2, there's an unlawful awarding of a tender to Medicare for a period of 3 years to the value of 360 million. She sets out that she suspects that
Please
the processes are flouted.
allow me to stop you. You have accepted, in your discussion with Ms. Sillo, that the only mention of General Masemola is paragraph 8. That's the first time she says anything about him. That doesn't mean that she has not investigated and this is what she has found. She has done that. That's why she gives you the background story in this affidavit. And then at paragraph 38, she says something that now directs to General Masemola. And in fact, on a reading of this paragraph, the way she says it, she may not have intended to, but the way she says it is, I advised him to terminate, and he did terminate. That's what paragraph 8 tells you. You say, well, she told him earlier, he took his own time to terminate when she had told him earlier. And all I'm putting to you is that which you are saying doesn't arise from this affidavit. On a sensible reading of this affidavit, and paragraph 8 in particular, or any paragraph in the affidavit, those facts that you are now speaking to are not here. Where did you get them from?
Commissioner Baloyi, I read paragraph 8 as her having advised him to terminate the contract. General Masemola ultimately terminated the contract. That he does. I read it from that ultimately. There wasn't an immediate action. It was ultimately terminated, and then prejudice was suffered. I don't take it from anywhere else, but just that reading.
But you see, to criticize him for not terminating immediately, you must know when was he informed.
I understand.
Logic dictates that.
It doesn't come out of here.
Yes, and that's a simple point I'm making, that on this paragraph in the whole affidavit, we don't know when she told him, right? So if we don't know when she told him, we are not in a position, and that you must accept, we are not in a position to say he delayed actioning her advice because she doesn't tell us when she informed him. We are not in a position to say because of his delay after she advised him, SAPS incurred 50 million rand expenditure, which it would not have incurred. It's not there aren't facts in this affidavit that make us able to conclude that therefore he delayed and he's liable, he failed to secure the monies or the assets of SAPS. You accept that?
I accept that.
All right, thank you.
Thank you, Commissioner. And I take it that it is General Matlow's affidavit that triggered the IDEC investigative powers and eventual prosecution of however many accused there are. Am I correct?
Correct.
You recall we started this conversation having considered what you stated, what you discussed with members of ad hoc. And there I referenced page 586 where Mr. Ngola told you that there was an allegation that IDEC is actively participating in a well-coordinated attack against General Mkwanazi, General Masumula, and General Kumalo. Are you aware of it? You said you've heard of that allegation, but there is no truth to it. After this entire exercise we've gone through, do you still maintain that there is no truth or there is no basis to even believe such a narrative or an allegation?
Chair, I maintain that there was no, sorry, I don't have my file for the,
No, ask
if you
me,
just
I'll-
repeat the words.
the engagement at ad
Ad
hoc?
hoc, yes.
It is it's file 3, page 586.
Sorry, file 3. Sorry, Chair.
It's quite in order, page 586.
586.
Midway the page. This is after, I guess it will be faster to find your own name, after you say that is correct. Then Mr. Ngola puts the question, there is an allegation. And then that's immediately followed by your response, and then you reference other criminal matters within the IDEX space. And you conclude, while we're at it, with the words, there is also no witch hunt against Lieutenant General Kumalo because there were no matters brought to IDEC prior to the referral by Mr. Adams. That's the part I'm reading. And I can very well perhaps appreciate the position you were in at the time you responded. Mine is slightly different. Do you still maintain the position after our 1.5 days of engaging with specifically decisions by IDEC targeting, no, wrong word, aimed at least 2 of these generals and the PKTT? Can you still say the narrative is baseless?
Chair, the response I have is, at no stage did any of these cases start on the basis of wanting to target any individual, even those that I mentioned. We dealt with the investigations. In the course of these 2 days of engagements, and in the manner in which we have engaged, we would have to accept that we could have done things differently and or could have done things better. But that does not in itself make it a witch hunt or a target. They were not targeted at all. I accept that process is criticized. The manner in which things were done were criticized. I accept that criticism, Chair. And what I'm saying is that shortcoming does not make a targeting. It does not make it a witch hunt. It does not of itself say, we did it this way just to get to them. In the manner that these matters were presented, it is clear, and from the lengthy debates that poor Chair has had to have with me in getting us to understand our logic versus that logic, it is clear that we worked on what we had, interpreted the law as we have. There is a difference of opinion, and that difference of opinion, Council, highlights that things look the way they do and should have been done differently.
We dealt with one of the many Section 28 summonses.
Are you leaving this
No,
page?
I'm coming back to it.
Okay, thank you.
And at 3361 file 9, and we dealt with that quite extensively yesterday. I'm at 3363. where following Mr. Adams's complaint, in whatever terms it was expressed, you signed off on a summons that asked for a litany of documents that had no bearing on the complaint, including a list of all provincial heads and section heads who were stationed in Division Crime Intelligence, the performance assessment of all major generals for that year, the advertisements for that position, audio recordings and interviews. Then you want documentary records that General Jacobs refused to return. We have established that all those factors bear no relevance to the complaint. And I think we settled that yesterday.
We have.
We have. Then you ask, in the same summons, for documentary files and applications for promotions and commanders and members of the political task teams through deviation. According to you, the PKTT did not feature anywhere. So once again, that is way beyond the scope of the original complaint by Mr. Adams. You recall?
I recall.
We then went to page 3531, which is annexure, you don't have to go there, annexure 397. That is the section 28, summons signed by Advocate Manilal, which wanted the identities and certified travel documents of PKTT members who went to arrest Mr. Adams. And he does so under the cast number relating to the Mukwele appointment. You could not explain that section 28, and I think we landed at a place where you said it ought not to have happened. Correct?
Correct.
In light of at least the three that I have named, logic dictates that it was a concerted effort to either discredit or somehow prejudice them. How can you sit there and you say the narrative is entirely wrong? And how do you suggest that it's just a difference of opinion? It's not. The facts, at least, are on the side of the narrative. What facts do you put forth to countenance that?
If you grant me an opportunity
Absolutely.
just to answer on why, because I had to ask the question because I wasn't aware of this, Commissioner Baloy. I did ask Advocate Manilal why this section 28 went out, and I give you the explanation as follows. Part of the bail conditions in that matter was that the accused, which at the time would have included Lieutenant General Khumalo, were not to have any contact, interfere with, and or intimidate state witnesses, one of which was Adams. It is seen on television that there is a group of persons that have gone ahead to arrest Mr. Adams. That arrest has nothing to do with us. It is the police must carry on and do their work. There were reports that it is PKTT members who went to effect the arrest. It is now at this stage not a secret that the coordinator of the PKTT is Lieutenant General Khumalo. And the purpose behind it from the prosecutor was to determine whether someone else within the PKTT approved those trips. That is fine. And that if it was in fact General Khumalo who authorized those trips, then he was sending people to deal with Adams, and it could have a potential of interfering with the bail condition. It was asked on that basis. What subsequently happened is Mr. Adams appeared in court. The charges are read. And Mr. Adams has a way of how he expresses himself in public, and the prosecutors decided, the approval notwithstanding, can we just stand back and let them continue with their work? It was
Advocate Johnson, I want to say if that's the explanation he gave you, it's a false explanation. Those individual members and anyone else in the world was under no bail condition that they could not, that's one reason, that they could not deal with any witnesses. There was nothing like that. If indeed the issue was to determine whether General Kumalo breached a bail condition, it was simply, and I'm sure Advocate Manilal knows that, you know that, it was simply a matter of asking General Kumalo, did you authorize an arrest of Mr. Adams? It's as simple as that. So if he gave you that explanation, it's false. He's not telling you the truth about why those questions, because that doesn't answer who went there, what are the names, give us the flight details. It doesn't answer the question whether there was a breach by General Kumalo of his bail condition. So no, I'm sorry, if you believe him, then something is wrong in this scheme of things. You should have, as soon as he said it, you should have seen it on his face, but that cannot be, it doesn't make sense. That you would go that way to try and determine that General Kumalo, whether or not General Kumalo has breached his bail condition. It's a false explanation.
So, Commissioner Baloy, I hear you. I'm conveying the reason that was given. But Commissioners would, and Chair, you would remember my answer yesterday. I did say that if, in the manner that this process was used and what was requested by asking about PKTT, then it is an abuse of the process. I did stand by that, and I did indicate that there would have been a better way for us to have engaged and to find out what had gone on. I'm not deferring from my point. I don't retract my point. I just wanted to merely give clarity on, because I had to ask. I didn't know.
My hope is you saw through that explanation. And that's what I would have hoped you would say, that this is what he says, but I have a problem with his explanation.
That is why I stand by the proposal I made yesterday. I can't deviate from that proposal.
Yes, thank you.
And the problem is in all that we have dealt with, particularly that arrest of Mr. Adams, it doesn't seem like anyone bothered to establish why he was being arrested. Had he committed, is he a suspect in a particular crime? How it comes across is because he was a complainant in some matter against inter alia General Kumalo, who happens to be the head of PKTT, a beggar subunit, that therefore Mr. Adams is somehow insulated from action by the PKTT, even where the PKTT has evidence of wrongdoing. That's the effect of it. So you brandishing that condition over General Kumalo to say, whatever wrong he commits, you dare not touch him because he's my witness, and if you do, you'll be breaching a bail condition. That's quite a bridge.
Of course it doesn't make sense, because what I did do in that engagement, I asked
Please continue.
I asked this morning, if in fact, heaven forbid, but if in fact Mr. Adams committed what one would consider a political killing, what would we have asked? Why would we have asked? Because they would still have had to do their work. So it all comes down to the same thing. If they had a job to do, they should have been allowed to do the job.
Yes. Now, this is important, again, once again, going to the narrative, because what appears, at least at first blush to me, is IDEC seemed to have this gunshot approach to everything. That gunshot approach has got serious unintended consequences.
Perhaps more appropriately, shotgun, not just any gun.
A shotgun approach. It's got serious consequences. Let's go to General Mato's referral, which we have agreed is wholly non-compliant with Section 27, which, based on our conversation over the past 2 days, did not trigger the mandate of IDEC. But we are where SAPS seem to have concluded an unlawful contract with Mr. Madlanga. But the prosecution for that sits on a highly questionable legal basis. Do you see the consequences? Because if the investigation is unlawful, the question must arise, what effect does that have on the prosecution, ongoing prosecution? Instead, had IDEC opted, in light of General Matala's affidavit, General Matlo, the Sotho names. Oh, I do apologize. I apologize to both General Matlo and Mr. Madlanga.
No, I think the second name is Madlanga.
Yes, I was going to say that, Commissioner Baloy. I saw
yes.
the words charity, Madlanga Matlo.
Thank you. Thank you.
No,
she intended to say Matlo, Commissioner Baloy. Just thank you, General Kumalo. My eye must have fallen on that. My apologies for that.
Now you've called him General Kumalo.
Okay, it's time for a break. Commissioner, I'll leave it there. The point I seek to make with you, Advocate Johnson, is that this affidavit ought to have at least triggered a conversation between yourself as head of IDEC and General Masemula, who at this juncture is not even a suspect in any wrongdoing, to alert him to the fact that there is a contract in your environment that there is reason to believe is tainted with illegality, and I expect you to take steps. The point I made that a faulty Section 27 may affect subsequent prosecution. You remember the fruit of a poison tree notion we discussed. And that's your challenge as IDEC. But if SAPS had run with the matter, they would never have this challenge. So because of the approach that IDEC has adopted, that running roughshod over everything, there is a serious risk, and I put it no higher than that it may have placed in jeopardy the very prosecution that is currently being pursued. Do you have a comment?
My comment, and again, you'll tell me, but it's not here, so my comment is that 27 was read, as I understood it this morning, with the preliminary report, which sets out a more factual basis that links the different people and perhaps sets out the offenses. It might be better if, so I see, sorry, Chair, I'm not being cheeky. I see from the time that my wish to finish by tea time might not happen. And so I'm tired. But so I'm thinking then that if we're going to have to take tea and we're going to now have to finish by lunch, that I would have to ask if we could just get them to send us this preliminary report, because I cannot agree to that contention. I'm giving you what I have, point. And then I'll take my cue from the chair about what we're doing for the rest of the day.
I would support you.
Go ahead.
I would support your request. I think it's a fair request, right? You have accepted that, at least on the documents that we have, on the reading of the affidavit itself, it doesn't suggest that such a preliminary report was provided. Yes. But since you've been made to believe that it was, I think it's a fair point that you consider it. You receive it, you consider it, perhaps you give the commission a copy, and then we see whether or not it addresses the concern that I have raised. And seeing as chair, it's 11:10, this might be an appropriate time. And on the second point, if I may say, not General Man, Advocate Johnson.
What's happening to you this morning?
I'm mixing up all my ranks and titles and everything. Advocate Johnson, insofar, I know it was your wish, you expressed it yesterday to finish by tea. If it's any consolation, my birthday was not too long ago. I reminded the commissioners I didn't get any gift. So it does happen.
So your
I'm so
gift
sorry.
will be to finish by lunchtime?
Yes, I have to.
Yes.
Have to finish by lunch.
That's why I was very cautious yesterday when you wanted to push for an undertaking that would be, and I refused. Please stick it out. It shouldn't be that long, Advocate Johnson. All right. Here's something I should say. In fact, I should have said when we started this morning, my ruling on the Karim postponement application is ready. Why I am not delivering it now or did not deliver it in the morning was because Mr. Karim's attorneys had not been advised. I gave an instruction to the Commission's attorneys to write to Mr. Karim's attorneys. So I will deliver the ruling at 2 p.m. before we commence. Let's come back at 11:45. Let's adjourn.
Thank you, Chair.
Good morning again. It's 11:44. We are ready to resume. Please make sure that your cell phones are on silent. Thank you.
Yes, Mr.
Thank you, Chair. Advocate Johnson, were you able to locate the preliminary report that you had hoped to locate during the tea adjournment?
That is correct, Chair. I have sent it to Mr. Maga to make sure that it goes through that.
That we receive it?
Yes.
Okay. Well, I'll await it. In the interim, your file 9 has been updated. You recall on that audit report, I indicated that it was availed to IDEC on the 26th of June. Now, it's a huge document. It's now added as CJC 398, starts from page 3534. And at paragraph 3, General Matlow states that her department, Internal Audit, Risk and Integrity Management, received a request from the Minister of Police on the 9th of January 2025. And that's what initiated this process. And as I indicated to you, the first 3 paragraphs are introductory. From paragraph 4, she goes into the detail of the documentation that was reviewed in the course of this internal audit. And it will run for 284 pages to our page 3817. And at 3817, she concludes, the above-mentioned transactions constitute corruption. On behalf of the South African Police Service, I would like corrective, remedial, and criminal action to be instituted in this regard. Then she's got the standard closing paragraph at 11, and there is my date of the 26th of June, 2024, which is when this affidavit was commissioned. You see that?
I see.
I had referenced it and I had said it does turn out that we ran into printing challenges. But during the course of the tea adjournment, they were overcome. And I thought to point out to you the basis for my conclusions. Thank you. Commissioners, unless there are further questions on this topic, I would like to move to the next. Thank you.
Sorry, Chair, if I may just inquire, then that preliminary report you will make available for the Commission so that they are able to deliberate it as a result of the engagements that we had, my not being here notwithstanding, because the purpose is to make sure that the Commission receives them.
Definitely, and in fact, I hope it comes before you leave the stand, because if it does, then we can formally place it on record as well,
Yes.
and its date, and then the commissioners will consider its contents. In the context of the wording of the affidavit, Section 27 referral, I trust that there's an explanation as to why it's not referred to in the Section 27 referral, but IDEC has it, and that there is a way to clear any doubt in the commissioner's mind that it followed subsequent to the initiation of the entire investigation by General Matlow. But we can only comment on that once we have had sight of it.
And just to indicate, I did procure it from General Matlow.
Noted.
Can I just
Yes.
clarify, especially if we are going to have sight of it after you're done, what are we looking for to see? Are we looking to see that she makes specific allegations against General Masemola And she states when it is that she informed him and that he delayed. Are you saying it will answer
Yes,
that?
and that there's an expansion of the offences, perhaps the other people, etc., but to your point as well.
Okay, thank you.
Thank you, Commissioner. Advocate Johnson, you recall yesterday Commissioner Khumalo asked you, he first made an observation and asked you a question, that there seems to be a hand in all this that we've spent the last 2 days discussing. And if memory serves me well, you denied. Now, my proposition to you is all that we've discussed about these investigations and aiming at the generals and the PKTT is wholly outside the mandate of IDEC as we understand it, as contemplated in terms of Section 7, 1 capital A. That's my assessment. And if you strongly deny that there is a hand in this, I would like you to explain to the commissioners on what basis, because this entire effort and exercise cannot have been to the benefit of IDEC. It's not to the benefit of the country to flout legislative prescripts in the manner that it would appear have been flouted by IDEC consistently and deliberately. And then to offer an explanation for why IDEC would conduct itself in such a manner, which conduct has the risk to destabilize the law enforcement environment and institutions. Thank you.
Chair, I did indicate yesterday, especially having been shown documents that I had not had sight of previously, if I can allude to perhaps two, is having a set of, if I get my days mixed, sorry, but having a set of 4 A1s taken by a person, Mr. Perama, then you have 4 A1s taken by Mr. Mansa, on a date when they are all supposed to have been together, executing one function together with the prosecutor. It's not for me to determine, I'm sure that exercise will still be done through your engagement, on which is the right set of affidavits, supplementary affidavits. That is one example. Closer towards the end of the day yesterday, I'm given a file, and in that file, we have the Public Service Commission report, dated 2023, Commissioner Khumalo, which I see for the first time. I only allude just to these two because they're very pointed and they're very factual in the nature of what is before us. I have had to ponder why we find ourselves in this position as IDEC, and why, while I accept, and I don't think that there's meanness when questions are posed by the Commission about, but why you didn't know, you should have read. I think the Commission understands I can't read everything and won't know everything, and I do have to trust and rely on my people. And I sat with a conundrum last night of why weren't these things brought to my attention? And if, especially with the Public Service Commission report, which is somewhat quite different, it should have stopped the day the report came in, because it should have been brought to the attention of the ID to say, ID, look, we thought we have a right to investigate this, but here it is. It has been done, findings had been made. that would have set that matter aside. That was not done. And now the question is why? Why wasn't I informed of the different statements? And what is the purpose then, chairs and commissioners, and forgive me if I'm rambling, but I have to think it out loud because it does not make sense. And I'm saying that there must then have been something else going on that I was not aware of. I cannot tell you what the something else was. I wish I could. I'm not therefore disagreeing with your counsel. I just needed to put it in a way that I am able to, unfortunately, not reconcile, but try and understand about what it is that was going on. You can't reconcile yourself with bad when at all times, I know that I made mistakes as the head of ID, non-intentional, and a lot of them are perhaps administrative things. But at no stage did I apply my mind in a way to seek to to vilify anyone. And so when you don't always have the full knowledge of things, I think the challenge I sit with commissioners is how will we as IDEC will only be 2 years old on the 19th of August. And as a young institution, what will be the mechanisms that have to be put in place for these underlying hands, persons and personas not to have the kind of influence there seems to have been had. I'm unable to take it further than that.
What could the something, as you put it, possibly have been? Surely you must have your ideas. Because one could easily say it was improper motives. But I'm not necessarily suggesting that. I want your own thoughts. What could the something possibly have been?
The something, Commissioner, I take it also from my time at the DSO, the Scorpions as they were. A lot of the times, and history had shown that, you find that staff get overzealous in wanting to present their case. But more often than not, you find that they engage with persons outside the purview of the work we're supposed to do, and you are not privy to that engagement. Mm-hmm. And so the mind you expect them to bring to bear on the mandate and on the cases is what you're engaging them on. It has been a past experience. In the way things happened this past week, it seems that there are other actors that might have been engaged with for us to be where we are.
And when you talk about other actors, are you talking about undue influence, perhaps?
I don't want to put it so harshly without having any, but to say that persons might have, for motives known to them, cast certain narratives or provided certain information. And you find that without of necessity, because what you expect, everybody gives information. Lots of people like to say lots of things. Do you verify it? Do you consider the source? And do you ever stop to ask, why did that source come to you? It is a question I've had to ask in this very painful few days you've had with me on the Section 27 referral of Adams. How it came about, what was the purpose, and look at where we are today.
But you cannot seek to extricate yourself as you appear to try to from what happened especially with regard to what you just referred to, which is the Section 27 referral. That was there for you to see, and right from the first day, we took you through that document, and you agreed when I suggested to you that it had open quote, nothing, close quote. You accepted that when I so suggested to you.
Correct.
So you cannot seek to say others may have acted wrongly. I will say to you, you too acted wrongly. And if there are questions to be asked about why, those must relate to you as well.
Correct.
On a document or on an affidavit that had nothing except for factual conclusions, you acted. It had to be your decision, you as the head of IDEC. It had to be your decision, and indeed it was, for any investigation to have gone on in the first place. Cut a long story short, I do not understand why you would want to blame others.
If I may.
As it should have, the buck stopped with you. And indeed, from where I'm sitting, it did.
And that is why, as I was carrying on with the Adams matter, that brought starkly home, from start to finish, the
Yes.
responsibility across the board.
Yeah.
In the first two instances, there are different instances that I used, as I hadn't been aware of them. But I sit here today knowing that I have to take responsibility
Yes.
for all the actions that flowed, intentionally or unintentionally. And I will be judged for those actions.
Yes, but why I'm going back to where we started on the first day of your testimony is because in the context of blaming others, you are referring to the Section 27 affidavit. And it is in that context that I say you cannot blame others.
It is my responsibility.
It is and it was your responsibility.
I accept that, Chair.
Thank you.
Thank you, Chair. Thank you. Advocate Johnson. As I indicated, I would like to move to a different topic. I have a few small topics to cover with you quickly, and I hope we can wrap that up in an hour. We now have it wasn't a promise, but a new hope that you'll be done by lunch. I hope to at least deliver on that one. Okay. The next issue is, do you have your statement filed close by? And in particular, the first October 25 statement. And at page 10, paragraph 30, you indicate once the investigation was concluded, this is the investigation following Mr. Adams's Section 27 referral. Once that investigation was concluded, you say you were briefed by the team that had conducted the investigations on behalf of IDEC. IDEC then applied for warrants of arrest against the accused. I then prepared a prosecution memorandum and submitted same to the Director of Prosecutions together with a draft charge sheet and a request for the enrollment of the matter. Now that prosecution note, memorandum you prepared is in file 8, page 3256. If you could lay your hands on file 8. It starts at 3256. And at 3257, paragraph 11, you state section 9.1 of the National Instruction 11/2017 states as follows: a selection panel may not be biased and must ensure that the selection process is free of nepotism or favoritism. A panel may never abuse its authority, and panel members may not influence each other to be influenced or to abuse their authority. So you're quoting from the National Instruction. At 12, you state, evidence collected proves that accused 1 to 6, these are the members, contravene the provisions of the above quoted sections to the benefit, I guess, of accused 7 without just or reasonable cause. In your paragraph 30, you indicated you were briefed. I take your use of the word at least implies engagement with the investigators to satisfy yourself that the charges suggested to be preferred against the accused have some factual and evidentiary basis. Is that a fair assumption on my part?
That is correct. The prosecutor would
Now,
also.
you stated paragraph 30, you prepared this prosecution memorandum, so you were armed with all that information. Are you able to quickly enumerate the basis on which you say the evidence points to the contravention of the provisions of that instruction by accused 1 to 6? What convinced you of the contravention? And at least, if we take the wording of Section 9 quoted, must show nepotism, it must show favoritism.
Sorry, I can't remember all the facts, except for what comes to mind, and I'm sorry if it's short.
No, accept, okay.
I think what comes to mind is that the selection panel tampered with the panel documents. The panel wasn't who they initially purported the panel to be. And when the investigation started, they had removed pages and inserted new pages, and that's what I recollect is in the docket. And there was an expert who does indicate that there was a tampering with that process, of the panel process, to misrepresent who in fact was the panel. And the only other thing I can recollect, and I don't mean to frustrate, unaware that this document had been created and authored, it therefore gave credibility to the process and to the panel, which would not have happened had this not happened. And I think finally the only other thing I do remember is that there was fraud or a fraudulent averment in the CV, which was deliberately not picked up so that a candidate could go through. But sorry, Commissioner, that's the only ones that I can recall from my briefing with the prosecutors on that.
No, I'm happy with that, and in fairness to you, I'm asking you to recall off the top of your head, so I'll accept what you say. Just the panel, you say that the panel was changed. That's your understanding?
That's my understanding. And that apparently there's a document expert report that would show how pages were removed for a list of changed names to then be
Of the
inserted.
panel.
Yes, but I haven't read that report. But I'm aware that there is such a report.
Okay, I don't know if you are able to follow Colonel Padiachi's testimony, because insofar as the panel is concerned, we are not aware of such a claim. The only complaint would appear as reflected in an affidavit, in a statement provided by General Khan, that the only issue was that the panel did not include General Khan. But there was no suggestion otherwise of a manipulation of the panel. Are you aware of that testimony? That the complaint was that General Khan was excluded from that panel?
No, I'm talking about something completely different.
Okay.
That there was when they are, the way it was explained, when they are done with the documents, they have a way of stapling the documents so that no one can tamper with the documents. I think it's a police process for security reasons. And it was found that the documents, in the way they were bound, it was tampered with for an insertion of a different page. And the expert is able to say that the documents were tampered with and something else was inserted. How that is all legitimated,
Yes.
I'm unable to explain.
Now,
But that was different from what, what's his name? Mr. Padiachi. I'm not talking about that. I'm talking
Yes.
about something completely different.
Okay, and now this, and that insertion of this page, is that what reflects the manipulation with the panel?
Yes.
As you understand? Okay. The investigator and the docket does not suggest anything of the sort. I haven't come across it. I don't think anyone has in this commission. If the docket provided us is to be believed and accepted, but nonetheless, I'll leave it there. You proceed then at 3257, no, at 3258, to speak of the urgency. So if one has regard to 3257, pages 3257, 3258, would it be safe to assume that the charges against these accused would technically be for or revolve around the breach of Section 9 of the National Instruction and would involve nepotism and favoritism?
Correct.
The charge sheet is attached to your memo. It starts at 3260. What I find in the charge sheet are significant, I think, in respect of each charge, is extensive invocation, reference to an invocation of the provisions of the Prevention and Combating of Corrupt Activities Act 12 of 2004. Now, I'm trying to marry the content of your memorandum, which complains in large part of nepotism and favoritism, and trying to understand how that lends us into PRECA, because the charges they face are predominantly PRECA-related. In circumstances where the charges based on PRECA, including gratification and I think commission of crimes in the future, don't find reflection in the original memo. How do I reconcile the two?
Sorry, for someone who wants to be out by lunchtime, I'm not reading very fast, am I?
It's okay, take your time. You haven't seen these in quite a while.
So for some of them, I see them on page 15.
Please reference the red number at the top.
This one.
You said page 15. I think you are looking at the typed page of that, whatever document.
No, it's got a black number.
Okay, the 3,000 and something top number. Are you in file 8?
So yeah,
Or are you working off your own copy?
I'm working on the chart sheet.
The charge sheet starts at file 83260.
3260. Okay. Sorry, I was in the.
Yes.
So the ones that I find relevant to the memo are on 3267. It would have been points
3267.
points 12 point 12.12, 12.13,
Okay.
12.14. We agreed about 12.15. I'm not going there.
So 12.15 is out.
Yes, I
Okay.
think Commissioner Khumalo and I dealt with that part of the gratification quite at length, so
Yes.
that falls away.
So 12.12 speaks of accused 7, and that is Mrs. Mkwele, submitting false and misleading information in the application and curriculum vitae. 12.13 is misrepresentations made by the accused with regards to the verting of accused number 7. And 12.14 speaks to accused 1, 2, 3, 4, 5, and 6 abusing authority vested in them by disregarding and not complying with SAP's national instruction. I'm still trying to get to PRECA. And based on the content of your own memorandum, because that memorandum, you recall, you submitted to the DPP?
So at the time of the memorandum,
Yes.
we had worked on that which is in 12.15, talked about the gratification in the form of employment. But since we've had the conversation, that's what I'm saying to you falls away. It no longer finds place there.
But it's got a different problem because your memorandum doesn't even invoke PRECA at all. It speaks of no gratification. It speaks of nepotism and favoritism. That's the point I sought to make earlier. That if your memorandum is intended to inform and advise the DPP, the only instrument you invoke at your paragraph 11 is section 9 of the National Instruction 11 of 2017, which you quote verbatim, and that speaks to nepotism and favoritism.
Is it maybe, and this is the best that they can do, paragraph 14 of the prosecution memo? That's the only reference to gratification.
Yeah, that is quite correct. You see what Commissioner Kumalo helps you with, reference to 14, that's your gratification. Now, you say after engagement with the commission, you have accepted that the gratification can't stand. Now, cause of my difficulty is that the charge sheet is with you as you prepare this memorandum. And in fact, in the memorandum, you say the draft charge sheet is attached. And yet, I seem to pick up a disjunction between your memo and the eventual charge sheet. I thought maybe I'm misreading the memorandum, and you might be able to help.
The charge sheet, the memorandum is a summary, but the charge sheet is also attached so that the DPP is able to apply her mind to both the prosecution memo and the charge sheet. So where one may have missed something in the summary, she's fully within her right, as is always the case, to go through the charge sheet and to also raise questions about the charge sheet and or any deficiencies in the charge sheet.
You recall when, I think it was on the first day or the second, you explained that your referral of the charge sheet to the DPPU as the IDEC, it's not to seek the DPP's approval, but to inform the DPP in whose jurisdiction you intend to prosecute, that you are enrolling the matter. So it's an information sharing exercise.
No, but I say twofold. I did say twofold in the affidavit. I said twofold. It also is its own checks and balance that if there is anything, because the DPPs also have a right to ask questions and to engage the document. I did say that in the affidavit. They're not a rubber stamp, and I don't believe that that's the impression that was created, commissioners, in...
probably the error is mine. I might have gotten a wrong impression.
Sorry, I said in the original affidavit was the first is the DPP is a measure for checks and balances. The second is so that the relevant DPP may grant permission for and or agree to the enrollment of the matter unless satisfied on the information given to him or her that there is reasonable and probable cause for the prosecution. The DPP will not place a matter on the roll for criminal cases. So it does give them latitude. They are not a rubber stamp.
I accept that. What is the purpose of a prosecution memorandum? It is to enable the DPP to precisely discharge the functions that you just enumerated, to enable them to make a decision. Do you consider your prosecution memorandum sufficient for that purpose? If the DPP would potentially read the two documents in the manner that I have and not see a correlation between the memorandum and the charge sheet. Because if they would, then they ought to have declined to prosecute on the basis that I don't understand where the charges, what the charges arrives from, because they are not covered in your prosecution memo. Am I being too pedantic?
I think council is entitled to her view.
Yes.
And I give respect to the colleague who went through this exercise, applied her mind, and was satisfied that based on the memo and the charge sheet, it was
The
adequate.
charge sheet is fully supported. Okay.
Yeah, I was going to ask, in fact, what it is that the DPP has. You give them the prosecution memo,
Yes,
and
ma'am.
then you give them the draft charge sheet.
Correct.
Is that all that they have?
That is all we give them.
So where a charge is about vetting, so I know we've had that conversation, but I want to use that as an example,
Okay.
that you have a count here which accuses Brigadier Mukwele in relation to her vetting position, and I think that's the very last count, where you say accused 6 acting in concert with accused 7. I'm looking at page 3279. It's the very last count. And it's just wanting to understand the conversation with Ms. Sulu. So if you look at 3279, that's the very last count. And in there, you're describing what accused 6 and 7 have done. And then you say, accused 6 acting in concert with 7, unlawfully, falsely, and with intent to defraud, give out and misrepresent to the SAPS, National Treasury, the public, that accused 7's application for security vetting was registered on the e-vetting system when in truth and in fact, accused 7 application for security vetting was registered on the old Inkwazi system as a service provider. That's in the charge sheet. There's nothing about it in the prosecution memorandum, no detail whatsoever. And if all that the DPP has or had at the time was the memo and this draft charge sheet, how could they have properly exercised their mind to approve this particular charge, for example, because they have nothing else? And it seems Ms. Silo must be correct to say on this charge at least, the DPP should have said,
asked for-
no, we can't have that unless you give me more. You accept that?
I accept that.
Okay. So at least on this, I mean, I'm not talking about the others. On this, at least the DPP doesn't seem to have properly exercised their mind if all they had was your memo and the charge sheet.
Correct.
Okay, thank you.
It's
What-
the same with saying,
You wanted to say something?
Sorry, Commissioner Kumar. What I wanted to say is, in such matters, more often than not, and not just in these matters, in a lot of other matters, what we tend to do is we will send it to the DPP. We also do indicate, kindly contact the prosecutor should you require clarity. And sometimes those conversations happen. I don't want to create the impression it happened here. I'm just saying there is room for engagement, and then they make up their mind. But there is also that process. I'm not saying that it did or didn't happen.
You don't have any, you're not suggesting here it happened because
No.
we don't have a record
We don't
of
have
that
a
happening.
record, yes.
Okay, thank you.
I was going to say, it's the same with the charge that in her CV, she misrepresented facts, but the charge sheet does not say what fact is misrepresented and what is the correct fact. And Commissioner Baloy's point that the DPP in file 62438, all he or she then says is that having considered your memo and the charge sheet, they are satisfied that a prima facie case has been made out against the accused and they concur with your decision to charge them. So it means they only considered the two documents that Advocate Sillo and Commissioner Baloy are referring you to. And it's the following day. I mean, there wasn't even a week to consider and come back to you and say, where is this, where is that? What is Inkwazi, what is e-vetting? They seem to have rubber stamped what was in the charge sheet, and there wasn't any engagement or consideration, because I doubt that any such engagement would have taken a day to finalize.
I accept that, Chair.
Thank you, Commissioners. Now, do you know when the decision was taken to prosecute the 7, had SAPS advised or sought to interdict the employment of Mrs. Mukwele? Was it suspended? Do you know what became of her?
No,
You're not aware?
no.
Having taken the decision to prosecute, did IDEC at least make a formal request to the National Commissioner to say we are proceeding with this prosecution and we have the applicant herself as accused 7 and we hold the position that her appointment is unlawful and either suspend her start date until the criminal case is disposed of, anything, just to get her not to be in office because you're suggesting that the appointment is tainted. Did IDEC take any such a step?
What IDEC does is we write up, I think the police call it a situational report after we have an arrest of any SAPS personnel across the board. We just give them a summary of the charges, who was charged, when they appear, and that then goes to the police. It is for the police to decide what steps they're going to take, but we have to put everybody in that was charged, not just one particular person. And then we escalate it to them for further action. Those are the kinds of reports I recall sending.
So the report itself doesn't even make a request for consideration by the powers that be within SAPS? Because if, considering the litany of sections of PRECA that you have invoked, this sounds like a grave, serious crime, and that in order to halt any adverse consequences flowing from that appointment, you at least would say, I urge you, National Commissioner, to consider suspending, giving effect to this appointment until the criminal case is done. You didn't, it doesn't go that far.
Not for a specific individual. When it is sent on the understanding that the police will take whatever action, almost invariably disciplinary action, and they will decide against whom that action is taken.
Staying then with your memorandum at 3258, you have under item E, urgency. You say the case, at paragraph 17, page 3258, and you state the case relates to crimes involving dishonesty and abuse of authority that were committed against an organ of state. The allegations also affirm that the accused relate to state capture in that they sought, through their actions and in the furtherance of a common purpose, to circumvent systems and processes to unduly benefit another. I want to unpack that paragraph. I'm interested in the urgency. What was the urgency here? Because Overleaf at recommendations 19, you state it is recommended that warrants of arrest of the persons involved in the commission of the offenses outlined in the draft sheet be obtained. So you were seeking these warrants of arrest as a matter of urgency. And the basis for the urgency, you set it out at paragraph 17. If Mrs. Mukwele was to take up her position at SAPS and precisely be involved in what IDEC fears, which is state capture and circumvention of systems and processes to unduly benefit her, what was the urgency in the arrest?
I don't know why it's got urgency there, because when you read the content, the content doesn't make anything, urgent.
It's your heading.
So I know it's my heading. I'm trying to figure out why the heading urgency, because the content doesn't talk to urgency.
I would have thought that the urgency is in the grave crimes that have been committed and the threat of state capture. At least that's how I read it. And if I'm correct in my reading, then the question is, how then do you allow that to take place by not at least stopping her assumption of office? But you are the author, and I do accept I may very well be misreading you.
Yeah, this notwithstanding, it's not our decision
No, I hear that.
about her not taking office. Ours is merely to summarize what the allegations are, or the charges, and to escalate it to the office of the National Commissioner. Whether they act with urgency and or not, whether they act against all of them and or not, has nothing and should have nothing to do with IDEC, because that becomes an internal process that must be governed by themselves. And so if at the time, even when they received, and I cannot remember the date, even when they received the situational report from IDEC, they still sought, if she wasn't already in office, to put her in office or keep her in office. That would have been their choice.
Yes.
Yes.
What you're doing is you're telling the DPP that to get an arrest warrant, because that's what this memo is about,
Yes.
is an urgent matter. So the question is, why was it urgent to get a warrant? Why was it urgent to get them arrested? Because that's what this memorandum is about.
I think for me, Commissioner Baloy, what does stand out in terms of memory is that it related to the abuse of authority that was committed against an organ of state, and that these arrests take place so that that abuse, alleged abuse, does not continue.
The abuse you're complaining about in your memorandum is they failed to comply with the instruction about employing this person. And you've explained that your briefing, your recollection, is you were told there had been manipulation of the panel of documents. So we're talking about, on this memorandum, you're talking about past activity, something that has been done and completed. You now want them to be arrested for that which you describe in paragraph 11 of your memorandum, because that's what you say is the problem. You want them to be arrested for non-compliance with that. And even your charge sheet speaks to past activity, except for that part where you say if she had been in office and continued to work, then she would have been doing, she would do what General Khumalo wanted her to do. That's the only future thing, but it's not in your memorandum. And working on the basis that your charge sheet, rather your urgent request for warrants of arrest and that they be arrested is connected to the breach of that national instruction. The question is, why is that matter that warranted that they be arrested, or that a warrant is issued on an urgent basis? And it's not to say, we are not yet at the conversation about why arrest. It is, why was this urgent to do?
I just have that Commissioner Baloy.
All right. I think I'm going to ask you a question about the arrest itself, but I just want to propose to you that this again, without in the absence of an explanation, it has appearances about it that the idea was to get them out of office, because once they are arrested, I mean, standard practice is when people are arrested and are presented before a court, they can never continue with their work. I think it's exceptional cases where people have been arrested and allowed to come back to work. But it seems this was the design, yet again. Arrest them, present them to court, then they won't be at work. That's my impression of what happened here. Do you want to comment before I ask you a question?
When they were arrested, I know you and I are going to have a technical discussion about what in office and out of office means. When they were arrested, they were not removed from SAPS. They were not able to go to the office, but they were still able to carry out their official functions. And I know technically, what's the use of carrying out your function in another place when you were supposed to be in one place? But if the motive was to remove them, then the ask would have been in that letter to the National Commissioner, when you're setting out the situational facts, they pose a risk and must be suspended immediately. And that was not done. We left it to the discretion of the police on how to deal with it.
Okay, that's a different discussion. We do know that there's a bail condition that says they must never go to the office. We do know from the documents that are before us that, in fact, at least General Kumalo, I don't remember the others, the National Commissioner put him somewhere else, right, in the meantime. Put him somewhere else until the issue of his bail was resolved, and then he brought him back to his substantive position. So there was an effect that came out of the fact of their arrest. There was a consequence to it. But my question, coming back to my question, why was it necessary to have them arrested? You could have summoned them, as you did with the National Commissioner, to come to court, as you've done in other cases. And I ask you this question because in the ad hoc committee, this topic came up, and you said that there was no risk of them fleeing and not presenting themselves to court. Why did you sign authority that they should be arrested?
So on a point of correction, I don't sign authority
No,
for them.
I misspoke.
Okay,
why do you sign a request? Why do you make a request? Because that's the sole purpose, in fact, of this memorandum under the heading recommendation. It is recommended that warrants for arrest of the persons involved in the commission of the offences outlined in the draft charge sheet be obtained. So you are asking for warrants of arrest, and we know it's history now. We know yes. You got that request. They were arrested. My question is, why, if you go to ad hoc committee and you say there was no need, there was never any risk that they would run off, and Colonel Pariachi accepted that they could have presented, you knew where they worked, you knew their addresses, why do you make that kind of request that they should be arrested? And you would have had the discussion, if you were following the evidence of Colonel Pariachi, you would have had the discussion about the least intrusive means being should be the first preference of presenting a person at court, because the whole point of an arrest, if that power is not exercised maliciously, the whole point of an arrest is to make sure that a person appears in court. Here, on your own words in the ad hoc committee, you say there was no risk that they would run off. Colonel Pariachi accepts that you knew their addresses, you knew where to find them. Why does Advocate Johnson request an arrest and that these people should be arrested?
I know that at the time, even though it was not immediately in that time, that we had had a lot of debates, and there were criticisms where we invited persons to hand themselves over. And we were seen to be selective when we asked people to hand themselves over. When we got the warrants of arrest, it was a method to secure their attendance. However, the manner in which their attendance was secured was we didn't go and arrest them where they were. I'm just explaining, I'm not saying that it makes it any better. The investigators called the different suspects, asked where they were, asked if they would hand themselves over, how much time they needed, told them where to come. And the actual execution of the arrest only took place then at the police station, and that was the means of then securing their attendance. But the process before that sought to be collegial and to ensure that they'll get to us as they get to us within the time frames they give us, that they should indicate what they need, that they contact their lawyers, etc. It wasn't, the process didn't seek to embarrass anyone.
It did, because with another witness previously, there were pictures that were circulated of General Khumalo in handcuffs. So there's no, and in fact, the very fact itself of an arrest is traumatic for any person. So you cannot sit there and seriously say, well, you know, because of how we did it, that mitigates anything. It doesn't. If you accept that as a matter of law and fact, there was no compelling reason to arrest these people, to bring them to court. If you accept that, then you must accept that it was a misuse of the power and discretion to arrest, because its sole purpose is to bring a person to court. And if you have other ways of bringing them to court, that must be the default. And that is a default that is not only about respecting human rights, but you know, we live in a society where you cannot infringe, you cannot breach the law, infringe human rights, take the most intrusive action and then say, well, at that time we were subject to criticism in other cases that we are selective. Then that's an admission that you used that process of bringing a person to court for a purpose other than what the law permits and prescribed should be used for. So you in fact concede in your long explanation that power was used for a purpose that had nothing to do with ensuring that these people do come to court. What do you say to that?
I hear Commissioner Baloy's explanation, and I'm saying that is the route we followed.
Did they appear in
your
court?
Argument
okay.
That it was not, there are less intrusive means.
Yes,
that should have been used.
Yes, and that it was an abuse of that process that's available to you.
I'm not taking it further than that.
You accept that?
I accept it.
Did they appear in court on the same day? Do you remember offhand?
I can't remember offhand. I'll have to check.
All right, but most importantly, it is you accept that in these circumstances, an arrest was not necessary. They could have been summoned to appear in court whenever you eventually presented them to court, and there would have been no harm to the state's case.
I accept it.
You accept that. Thank you.
Thank you, Commissioner. On that score, then let's go. You recall you effected corrections and amendments to your original October 25 statement. And in that statement, you deal with the arrest of General Khumalo. We now have deleted the entire paragraph 14, and in fact 15, and replaced it with what you set out in your third statement at paragraphs 10.1 and 10.2. Your third statement, page 3. So we will work off the latest version. So your new paragraph 14 regarding General Khumalo's arrest, you state that Lieutenant General Khumalo was arrested after he had landed at Oliver Reginald Tambo International Airport, Otia. I do not recall where he was traveling from. I was informed that at the time his co-accused had already been invited to report to Brooklyn Police Station. If whoever the arresting officers were aware that he was traveling from somewhere to Joburg, why was he not given the courtesy like others to report to Brooklyn Police Station upon his arrival in Johannesburg? Why did it become necessary to go to set up a welcome party, a welcome delegation for him? Because you stated your new paragraph 15 then, the investigators went to Otia to inform General Khumalo that there was a warrant of his arrest and for him to hand himself over. But that doesn't make sense. They didn't go there to inform him so that he can walk himself to Brooklyn Police Station. They actually went there to arrest him. So basically what I suggest, in your new paragraph 14 and 15, you try and downplay the arrest by suggesting that as with his co-accused, he was invited to report to Brooklyn Police Station, and I'm saying it's not correct. Factually, we know that is not correct.
Sorry, Counsel, which part is not factually correct?
That they had gone to Otia to invite him, as they did with his co-accused,
Yes.
to report himself to Brooklyn Police Station.
But that is what they did.
No, they went to arrest him.
No, they called all of the accused.
Yes.
And sorry, they were not accused. Called all of the suspects and invited them to hand themselves over at Brooklyn.
Can you stop there? Was the same courtesy extended to Lieutenant General Khumalo?
That is what I understand. They went to...
That's not what you have in your
They
statement.
went to Otia to inform him that there is a warrant for his arrest, for him to hand himself over. And he then accompanied them to the Brooklyn
Okay.
Police Station.
Then I must accept that,
the-
in respect of all six, this is time that's putting pressure. I accept that the arresting officers went to all their homes and offices and told them to please leave their offices and go to Brooklyn. It can only make sense in that manner. Because otherwise, I suggest, to invite them to report must be by means other than physically going to them. So you either call, send a message, send an email, some other form of communication. And my argument is, if IDEC was able to extend that courtesy to all other six, did it do so in respect of Lieutenant General Khumalo, such that if he says, oh, I'm out of town, when are you coming in? I'm coming in this afternoon. As soon as you arrive, please present yourself to Brooklyn Police Station. That's all it took. But it doesn't sound like you did, or by you, I mean IDEC did.
The investigators would be best able to answer only because they had that direct engagement with him and had the direct engagement with the rest of the accused.
But you have offered in your statement how they came to appear at Brooklyn
Because
Police Station.
I needed to account, and
Yes.
this is the account that I was given.
And so too must you accept that the purpose of going to Otia upon his arrival was not to inform him. I have a sneaky suspicion that he's got a telephone, he's got a cell phone, that somebody within IDEC, the number may have, including yourself, considering his seniority. And that was easy to call him, to send him a message, a WhatsApp, Signal, what is the other new one? The Swiss one, we learned something.
Okay, I don't know about the Swiss one, but
I learned.
I take your point.
Yes.
I take your point.
I'm saying, actually what you are stating, it's a rather misleading. They went at the airport to arrest him, period. They went there to arrest him. And by arresting, it doesn't mean they have to speak gruffly to him. They could be very well nice. But at that point, he no longer had an option to go anywhere but straight to Brooklyn Police Station. That in any language constitutes an arrest. Would you accept that?
I'm accepting your point.
Thank you. That now, as I understand, that was, I call it the first arrest, and not that there was a second, but I do so to distinguish it from what I call the aborted arrest, the one of June 18th. Yes, June 18th, 2020. Yeah, thank you. Now, the one of June 18th is in respect of docket 543/06/26, the second docket. Now, it was not that arrest or application for those warrants. They were not in any manner prompted by the arrest of Mr. Fadiel Adams by the PKTT. No, there is no connection between the two.
No.
Okay. Did you ever have a conversation with DPP Advocate Harrison from KZN regarding Mr. Adams's arrest, whether impending arrest, issue of arrest warrant, or his actual arrest? Did you ever have a conversation, whether it's orally, by WhatsApp, email, whatsoever? Did you have any communication with DPP Harrison regarding Mr. Adams's arrest?
I did. I also think I wrote her a letter. The gist of the conversation was just to indicate, I'm not sure if you are aware that Mr. Adams is a witness and in an IDAC matter. And I just wanted to know whether or not he's going to be arrested, just so that we know how to handle him, because we are one NPA. It's actually in a letter, and I think it's best that I make that letter available.
Yes, please.
I was already told I'm overdue in my office, so I'm going to go there when I have time this afternoon, and hopefully still have access to the emails. I did write her a letter, and I made it very clear in the letter, and I think that is why it's important the Commission get the letter. I said, I do not want, I surmise, but I said, I do not want her at any stage to think that IDAC is indicating that he should not be arrested if he committed a crime. I just thought that because it was open knowledge that he was a witness to IDAC, just give us a heads up, because witnesses become difficult and they become difficult to manage. It is on that basis and that basis alone. And the letter is very clear about that.
Yes. But why do you address that inquiry to the DPP and not to the agency arresting him, the PKTT? What does the DPP have to do with that? How would she potentially assist you?
The DPP would then be able to, when we write, we engage in that way. I write to the DPP. If she wanted to know something that was happening in Pretoria, she would write to the DPP in Pretoria. And the DPP goes ahead and finds out if there is such a matter and who's dealing with the matter and what the matter is about. And the DPP was able to find out. And indicated not the details, but that they were looking at a matter, there was a criminal matter, and we left it at that. We did not engage again. And after that, we did see the arrest as it happened.
I still don't understand how she would assist you, because at that time, if she would have been involved in any manner, might have been by authorizing the issue of the J50s. So as I think of things, that's the only issue you would have been talking to her about. But to find out why this person is arrested, you are directing the query to a wrong person. It should be to the agency that arrested him, which is the PKTT. Are you sure you are not engaging here to find out who authorized those J50s? No. Okay.
She didn't indicate that there were any J50s at the time either. There was nothing to engage about the J50s. Council.
Okay. Because I'm still at a loss as to why you could potentially call the DPP following an arrest of a suspect in a matter that is not on your table.
It wasn't following the arrest.
Oh,
We
regarding,
had-
sorry, I
Sorry.
agree, regarding the arrest, whether it was before, during, or after. I don't see, I correct myself, I take your correction.
So, because we've had challenges in other matters where an agency arrests a witness.
The DPP did not arrest him.
No, an agency arrests a witness in another matter, and that matter becomes prejudiced because the witness now no longer wants to testify in a matter where they had been a witness for quite some time and want to know from you, the team for whom they are going to be testifying, why didn't I know I was going to be arrested? We don't know all their cases. What it is it becomes a bit difficult to manage the relationship. And so within the NPA, we have undertaken to at least inform one another. No dictate, is to just indicate the person you arrested is my witness, and that is it. And that is where we've taken it, and that is where we leave it.
Okay.
It's not the first matter.
I guess my challenge is I don't see how a conversation with the DPP would go where you say to the DPP, the person you arrested, because the DPP didn't arrest that person. So how that conversation even starts to land where you suggest it did, I can't wrap my mind around, but you know, I'll catch up. It's exhaustion perhaps. Okay. We have reached our crisis point, which is that it's 13:02.
And I can hear the chair whispering there. He says, Johnson, you can go home, girl.
Did you hear me whisper back to him, no, Chair, she can't as yet?
No, and Commissioner Baloy says, no, you don't get to do that, Chair.
All wishful.
Ms.
I'm in
Silo,
your
how
hands.
much longer do you think
Chair.
we're going to be? I'm asking because we could continue and have a late lunch.
Okay. Yes, we could. May I
but
not
that-
attach a time because I don't think I've kept to any that I've previously offered. But, okay, I have 3 little matters to
No, when you do
address.
them like this, they don't look little to me at all.
No, what's remaining, I promise you, they're very little.
Should we rather
It's
take
a
the-
bit intimidating when she says
Yeah.
3 little.
Perhaps let's take the lunch agenda
Okay.
and then,
Chair, may I
Resume.
ask, I know
Yes.
you had an engagement already at lunchtime for a judgment. Will we come back, finish this, and then you proceed with the judgment, or you'd have us wait out?
let me straight away say it will just be the ruling with no reasons. So.
We'll be back.
You should rather either sit there or sit anywhere but inside so that we start immediately.
Thank you.
Thank you, Chair.
Let's adjourn and resume at 2 p.m.
All right, it's 13:59. We are ready to resume. Please make sure that your cell phones are quiet. Thank you.
The ruling I'm going to make is in relation to the postponement application of Mr. Karim. Having considered all the papers filed and oral argument presented by both sides, I make the following ruling. 1, the hearing of Mr. Karim's evidence is postponed to 14 August 2026 at 9:30 in the morning, at which hearing Mr. Karim shall be required to appear and testify in person, subject to paragraph 2. 2, Mr. Karim will be excused from appearing on 14 August 2026 only if, 2.1, he has voluntarily subjected himself to an independent evaluation by a medical specialist agreed by no later than Monday, 3 August 2026, between his representatives and the Commission's evidence leaders. And 2.2, such independent medical professional has provided a medical report to the Commission by no later than 12 August 2026, confirming Mr. Karim's inability to testify on 14 August 2026. 3, failing the agreement envisaged in 2.1, the independent evaluation and report envisaged in paragraph 2.2 shall be performed by an independent medical professional nominated by the chairperson of the Association of Medical Professionals, in the field of medicine in which Mr. Karim's current doctor practices. 4, the reasons for the ruling will be issued at a later stage. I hand down the ruling. As usual, the ruling will be uploaded onto the Commission's website. Thank you.
Thank you, Chair. Advocate Johnson, you recall before we broke for lunch, you indicated that there was a preliminary internal audit report that had been availed. I confirm a document has been availed to the Commission. Commissioners, you have run out of space in file 9, so it's a little file marked Exhibit File 9, capital A. It should have been put on your desk. Yeah. Advocate Johnson, you have it before you?
I do, ma'am.
It's marked for record purposes CJC 399 and starts at 3818. I've just received this and I just quickly scanned it. You recall that you indicated that it was received at the same time as the General Matlo Section 27.
That is what she informed.
That's what you are informed. And I looked through this, so if we could just flip, and the purpose really was to see the extent to which that Section 27 even implicates General Masomula. Looking at it, I see that it gives a background to the bid itself, and at page 3823, it is signed 29 April 2025, at the bottom there. And if we go beyond that, it seems to have an annexure. and addresses at 3824 accountability, responsibility and distribution. It kicks off with a detailed analysis of the bidding process, and it gives all those details, the bid evaluation, and at 3838, it then makes certain observations regarding red flags and or evidence of fronting in the bid of Medicare 2420, sets out the basis for concluding there were red flags, then addresses at 3839 the various companies registered to Mr. Madlanga, at 3840 registered to Mr. Van Wyk, as well as other 12 companies registered to Mr. James George Murray. Then at 3841, it makes general findings at paragraph 3.4. And they are set out there, but the interesting thing is that the conclusion 3.7, it concludes the bid adjudication committee did not exercise due care in considering an evaluation report from the bid evaluation committee. Then it draws conclusions at 4. At 5, recommendations 5.1.2, the recommendation is that the bid should be terminated. The accounting officer should seek legal counsel on how to proceed with termination. The termination of the bid is consistent with section 23.1C of the general condition of contract, which states that the purchaser, without prejudice to any other remedy for breach of contract, by written notice of default sent to the supplier, may terminate. At overleaf at 3843, it states evidence 5.1.3, evidence of procurement irregularities were observed in the bid. Therefore, the bid is currently being subjected to a forensic investigation with a view of pursuing a criminal investigation against the supplier. So, and that seems to be the conclusion. So we know this is, the preliminary report is available on the 25th of April, 2025. And in terms of...
Sorry, Ms. Where do we see the 25th?
Me?
Where do we see the 25th?
Oh,
date?
that is at...
It's on the second page, Commissioner Baloy, I think it's, yeah.
Second page of the report.
It's 3823.
It's also there.
Oh,
It's signed and dated.
yes, thank you.
Yes, by the acting Chief Audit Executive T.E. Mukwana and by Chief Risk Officer Major General Matlou. In fact, it's the 29th of April. 29th of April, 2025. And we know from General Matlou's Section 27 referral that by the 15th of May, General Masemola had terminated that contract.
So 2 weeks later. 2 weeks after this report, General Masemola had terminated the contract.
I get it, Chair.
And remember, as Advocate Sillo said, 5.1.2 said he must seek legal counsel on how to proceed. So one must assume that in those 2 weeks, he sought legal counsel.
That is correct.
Thank you, Commissioner. So, and I know I read it very carefully. Where I land is, insofar as General Masemola is concerned, it doesn't cure the shortcomings in the Section 27 affidavit as submitted by General Matlou, because it is absolutely silent on either irregular conduct, unlawful conduct, criminality attributable to General Masemola. Is that your... And I know perhaps you only had an hour as well to go through it. Is that your interpretation as well?
From the
From the
preliminary,
document
yes.
itself? Yes. Then I think that then settles the matter. And it goes back to the concession you refuse to give me, and you say it's dependent on the contents of this document. You've seen the document now. Are you going to agree with me? You said it would be irresponsible, I think, to agree with me without having had sight of the preliminary, the interim audit report you have now had sight of. So on the basis that the condition has been met, I take it won't be irresponsible to agree with my conclusions.
Let me think. We didn't finish before lunch, so maybe I'm still disagreeable. No, I agree.
Thank you.
I agree.
We had just dealt with the arrest and second intended arrest that didn't take place of General Masemola. I would like to move on. Yes, we are closing 9A. Thank you, Commissioner. Chair and Commissioners are suggesting that I move on from the issue of the arrest of General Masemola and the intended arrest for June 18th, 2026, which was not executed.
Sorry, it's Kumalo and Madondo.
What did I say? I said Masemola.
Masemola.
I'm getting everything wrong today, ain't I? I just, my apologies. There was never an intended arrest for General Masemola, General Kumalo, and General Madondo. Advocate Johnson, a document will be distributed to you. Don't mind it for the moment. We'll refer to it when the time comes, and we'll have a discussion on it. I then want to move. Are you aware that after the arrest, yes, you are. After the arrest, the accused applied for bail in the magistrate court, and they were granted bail. You are aware of that.
Which matter are we talking about?
In the Mukwele matter.
Correct.
Yes. And if you tend to, I think it's, if you bear with me, file 7, page 381. Page 3, no. CJC 381, page 2948. Apologies, Commissioner. It's CJC 381, page 2948. Those are the magistrate's notes taken during the bail hearing. Are you aware of the condition granted, bail condition granted by the magistrate at 2949? It's condition 3. That accused number 1, 3, 4, 5, 6, and 7 are prohibited from being at any premises of crime intelligence within the country, RSA, while the matter is pending. The fourth condition was Mr. Brian Padiachi will assist the accused with the collection of any matters or items of personal nature the accused may have at the premises, in the crime intelligence officers. I don't see everything there, but that's the gist of the fourth condition.
May have left.
Or may have left, thank you, Chair. May have left at the premises of any crime intelligence office. Now, you were asked about this condition at the ad hoc committee, you recall?
I must have been.
Let me see if my record keeping is what it ought to be.
Three.
I've lost my place, but
Are you perhaps looking for page 543? It might give you a sense of where you're trying to go.
could very well be, Commissioner. Yes, it's page 543, thank you. Thank you. And it starts at 542 at the bottom. And at the bottom, Advocate Arendse, referencing some of the complaints by Lieutenant General Mkwanazi at the press conference of the 6th of July, 2025, states, now he being reference to General Mkwanazi, makes reference to one of your investigators, Mr. Brian Padiache. Let me put to you two allegations made by Lieutenant General Mkwanazi made in his affidavit. He said, quote, a further condition is that the accused required anything, if the accused required anything related to their work, it could only be obtained through the intervention of the investigating officer. This is in relation to General Khumalo. Then at the bottom of 342, it indicates that General Khumalo has applied for the bail conditions to be amended, but the hearing of this application to amend has been postponed on numerous occasions. Then you respond to this bail condition at page 543, and you state the assertion being that Mr. Padiache would be allowed to have access to criminal intelligence is incorrectly interpreted, mainly because we have witnesses at CI. Those witnesses had indicated that they had been intimidated and victimized